Mr. Ivy, this is the staff attorney. Hi, thank you for joining us on such short notice. Are you going to request takedown? You're muted, but I think you indicated no.
Correct. I am not requesting it be taken down.
All right, thank you.
Mhm.
Mr. Freehoff, have we heard from the attorney who requested this emergency hearing?
Sorry, Judge. I was just sending him an email. No, I have not. I will reach out to him via his phone number now. Thank you.
Okay, thank you.
Hello, can you hear me?
Yes, we can hear you, Mr. Winfrey.
Yes, Mr. Winfrey, we can hear you. Can you hear us?
Why can't I hear you? Judge, can you hear me?
I can. Can you hear me?
Yes.
I can't hear you. Oh, let me try my speaker. Let me try something else. Judge, how about now?
I can hear you. Can you hear
Okay.
me?
I can hear you. Yes, ma'am.
Okay, excellent. So this matter is an emergency TRO that was requested by Mr. Winfrey on behalf of his client, the estate of Tequila. The first name is so distinctive that I remembered it. Tequila Gordon.
Yes, Judge.
Thank you. My understanding is that the house that Ms. Gordon owned at the time of her death is slated to be foreclosed tomorrow. My
Yes, Judge.
understanding from having reviewed the pleading is that there was an estate appointed in February after Ms. Gordon died. And the estate alleges that it was not properly notified of the intent to foreclose by statute or pursuant to the terms of the security deed before the foreclosure. Is that accurate,
Yes.
Mr. Winfrey?
That's accurate, Judge. Yes.
Okay, excellent. And on that basis, the estate is requesting a temporary restraining order prohibiting the foreclosure sale going forward tomorrow.
That's
Okay.
correct.
Thank you, Mr. Ivy.
Yes, Your
First
Honor.
of all, thank you so much for making yourself available. I know it's short notice, but our typical practice is you would much rather, even on short notice, I assume your client would much rather have a chance to have a response before I either do or don't enter a foreclosure order that could set back the foreclosure without having heard from your side by as much as, 2 months. So
Yes,
anyway, Mr. Ivy, if you would like to respond on behalf of the mortgage company.
sure. I'm looking at, and as I understand, there was also an allegation in the complaint that PennyMac Loan Services, Dallas Ivy for PennyMac Loan Services, did not give out the pre-acceleration notice of default.
Right, and that was the one I was referencing regarding that they violated the security deed as
Correct.
well as the allegation that they violated the foreclosure statutes. Go ahead.
Yes, and I do see in our file both the notice from PennyMac, the pre-acceleration notice. I can share the screen. I can try and share the screen. My Zoom skills are limited, as well as the foreclosure notices that were sent to Mr. David Gordon.
Okay.
I can attempt to do that. Okay. Is that appearing on screen?
It is. I'm looking at
Okay.
looks like a barcode and a generated notice to Tequila Gordon at 2860 Summit Parkway Southwest, which I believe is the disputed address.
That's correct, Judge.
Yes, and this was sent. I did have time to redact the loan number. Just we do that for privacy reasons, of course.
Okay.
Anyway, it's the notice that was sent by PennyMac, dated March 10, 2022, notice of default and intent to accelerate. I think
And that would be the security deed that was the security deed obligation to provide notice of acceleration and the procedures by which a person might be able to address the acceleration. Is that right, Mr. Ivy?
correct, that's right. And I think that language is found in this notice letter in this paragraph here. If you wish to dispute the delinquency, you have the right to cure or reinstate the loan after acceleration and the right to assert in a foreclosure proceeding or to bring a court action. So I think this is sufficient for purposes of paragraph 22 of the security deed. Foreclosure notice. There are a number of notices. This, however, appears to be the one that was sent by certified mail on December 30th, 2022 to David Gordon as administrator, sent to the property. And again,
I'm sorry, what was the date on that again, sir? Mr. Ivy?
Based on this information,
December 30th.
it shows December 30th, 2022. So, and then here's the letter corresponding with that.
And when was the foreclosure notice published?
It was published, let me find the affidavit here. I do have an publisher's affidavit dated February 2nd, 2023. The ad was run in January, 3 weeks in January, and then February 2nd. So that complies 4 times prior to sale date, I believe. So and here is the ad, or that's attached to the affidavit. So I think that notice was proper. I would like to address, I guess, a procedural issue, and maybe it's just what I have received. I don't see that we have a verified petition or affidavit of any kind, which I think is a requirement to seek injunctive relief. Also, there is a general equitable requirement, 23.110, I guess, the general maximum regarding equity. He who seeks equity must do equity. Here, that would require Mr. Gordon to tender the amount of the loan that's admittedly due. I can cite Your Honor authority for that, but there's general, I think you're probably familiar with that general basic requirement. And from what I see in the file, this was previous. This matter was. I've seen a statement. I don't have an updated amount. Of course, the debt's been accelerated at this point, but I see a statement dated May of 2022 in the amount of $14,263.55 that was due, and then just carrying that out to February, that's another $12,581.04. For my limited math skills, almost as limited as my Zoom skills, I come up with $26,844.59. And I do show the accelerated amount was $285,802.83. So I think, I don't know all the what the estate. I assume they're trying to sell the property. I don't know that for sure, but at any rate, there should be, in order to grant that injunctive relief, the estate should have to do some type of equity. So
okay. Well, let me start off and save Mr. Winfrey a little bit of trouble. You may not have received it, Mr. Ivy, given how late you were jumping into this at my request. But the document that was filed, the petition for emergency injunctive relief, does include a verification by Mr. Gordon as the last page. So procedurally, I think it is sufficient. Now, the issue as to tender, I'm not there's no allegation of tender in the petition. I'm not aware of any tender offer, but I also am not sure I agree with you that it's 100% required in terms of a specific offer of tender, but that's probably an issue for another day. But Mr. Winfrey, I just wanted to save you the time on that issue of the verification and then give you a chance to respond substantively.
Okay. So, Judge, my client did not receive any of those notices. So just as a procedural matter, factual matter, so you understand, my client lives in Oklahoma. After his sister passed away, he had her information forwarded, her mail forwarded from there to his home out in Oklahoma, so he could make sure he received all of the documentation. I asked him several times before I even filed this, went down this path, check your mail. Do you have any notices? And his testimony was that they didn't have any notices accelerating or.
Hang on one second, Mr. Ivy, you're still sharing your screen.
I'm sorry.
But to that point, Mr. Ivy, one of the letters that you sent to me, perhaps two of them, the two foreclosure letters, the acceleration letter and then the foreclosure letter, I think you indicated they were sent by certified mail. Do you have any Were they not sent return receipts?
I don't. Got. They
And I
were.
don't mean to imply that they're required to. I just,
Well,
honestly, that'd be a quick way to solve the issue if it. if
Yeah, I showed what I see is that it was returned, or it was not accepted, and so it was returned to our firm. And for whatever reason, it looks like our firm signed, for somebody with our office, when they got the return mail, signed the return receipt.
Okay.
I don't know why that happened, but it apparently did. Now, I think, as Your Honor alluded to, actual receipt is not required.
Right.
If the estate had, given an address and asked that notice go to that address, I think that would have been more proper. So as it stands, I think PennyMac, the notices were in compliance with both Georgia law and with the terms of the security deed. If there was no request that it go to another address, or if there was no request for it to go to another address that the lender was aware of, then I think the only notice is the property.
Right. I wonder too if it's, I mean, the post office is not exactly what it used to be, but I wonder too if there's a policy that they don't forward certified mail. But some, I don't know, but unfortunately for Mr. Gordon, my understanding of the law is that Mr. Ivy is correct, that proof that it was sent is what satisfies the statute and what I think would be minimum required to satisfy the language of the security deed. And it is unfortunate that those notices were not forwarded to Mr. Gordon. I agree with Mr. Ivy that if that was an issue, it could have been, a new address could have been provided in terms of where to send notices. And in the absence of that occurring, and the documentation that PennyMac, is that the entity that PennyMac has been able to provide, I'm not sure that the relief that Mr. Gordon seeks would be appropriate in this case. Anything that you want to add, Mr. Winfrey?
Yes, Judge, before you make a ruling, if my client was able to make a tender into the registry of the court, would you be willing to issue the order at that time? Because the house is being listed for sale, and it's been listed for sale since like August or September. Mr. Gordon tried to sell it on his own prior to that. Miss Gordon, when she died, she was in the hospital for several months and incurred a medical bill over $1 million, approximately $1 million. And Atlanta Medical Center has reduced that bill to approximately $280 some thousand dollars. And the only significant asset that's in the estate that could pay anything portion toward that bill is the house. And so if we need to tender something, I think he might be able to tender something, but we're still trying to sell the house as we speak. We're trying to get money to PennyMac, but we're also trying to take care of some other assets, other debts of the estate as well.
I understand. But I think where I'm confused is although I certainly don't envy the situation in which Mr. Gordon finds himself, PennyMac would be a priority lien holder here. Correct. That would have the ability to recover. I guess perhaps the unspoken that I'm missing is that this house is worth substantially more than the mortgage value amount and would likely be able to satisfy all of these issues.
No,
but for a foreclosure sale price. Yeah,
so if you were to issue the order and we were allowed to sell the house, PennyMac would be covered in full, and then there'll be some portion that Atlanta Medical would receive, but PennyMac would be covered in full. I don't think Atlanta Medical would be covered in full. But if the foreclosure goes through, then I don't think Atlanta Medical gets anything.
Mr. Ivy, what are your thoughts, sir? And hang on, forgive me, Mr. Ivy. Mr. Winfrey, when you say tender, you're talking about the outstanding balance, correct? Not the value of the house.
Correct.
Okay, thank you. Mr. Ivy?
I don't have any valuation information. I don't know what the property value is. occasionally that will be provided when our firm receives a referral for a foreclosure. I don't know in this case if we've got that. Don't know how current that would be anyway. So I don't know how to answer that. Whether PennyMac will be satisfied in full or not.
Well, I guess here's my thought. As a general matter, as I've already said, I think it is likely that PennyMac has provided me with enough information to indicate that the notices were sent out in compliance with both the security deed and the foreclosure statutes. Now, in terms of the case, the actual foreclosure sale going forward tomorrow, what I understand Mr. Winfrey to be asking is there's no harm to PennyMac if we tender the outstanding balance that's owed, because what would that would essentially delay a possible foreclosure by what, another 2 months? Is that right, Mr. Ivy?
Roughly, yes, Your Honor.
Okay. And just in terms of, I understand the request to be one of equity rather than a sort of procedural check the box and are we appropriate here? And I guess that's sort of my question to PennyMac, not that I'm asking you to consent to anything that Mr. Winfrey is requesting, but in terms of the possibility that PennyMac would be more likely to be made whole by an actual sale rather than a foreclosure sale, and that the estate is in a position to make a tender of the outstanding balance. What are your thoughts on that, Mr. Ivy? Well,
I think it would all come down to valuation, and I don't have that information. Sometimes for, if there's a lot of equity there, foreclosure sale is just as, PennyMac doesn't care how, the lenders don't care how they get satisfied as long as it happens. So, so I don't know what else to say about that. I can tell you I've given the amount that I think would be in a reinstatement. Now that does not include the foreclosure fees from our firm for the work that's been done. That would be another, I don't know, $1,400, $1,500, something in that range. But I mean, so that's what, at least what PennyMac would be out, in addition to the amount that I stated, the $26,844. But
well, a quick Google search indicates that it's listed for $380. Whether it would actually sell for that, and I have no idea what the housing market is doing currently. Right. Hang on one second.
Mr. Ivy, do you think there's you and I can talk offline and see if there's something we can work out?
I'll be happy to speak with you. I don't have authority to do much of, to do anything, quite frankly, right now. But I'll be happy to talk to you if you want, if you would like to talk. If you have something you want me to present, I can certainly do that.
Okay. Are you with Aldrich Pike, or are you with another firm?
No, I'm with Aldrich Pike. Yeah. Okay. Jennifer Shin is who I know you've been communicating with. So, and she'll be the one that would have the direct contact anyway, but.
Okay. I know that we're up against a time deadline because of the planned foreclosure sale, which typically take place at what, 8 o'clock in the morning?
Sale hours between 10 and 4.
10 and 4.
4 p.m.
Okay. Here's what I would like to do. I want to sit on this for a minute and think about it, and look at the equitable interests that are at play here. And what my intention will be, since I know you need to know an answer. My intention would be to give you an answer no later than 4 o'clock today. I just want to have some time to take a look at it. In the interest of full disclosure, I do want to be clear that if I were to sign the order and prevent the foreclosure sale from going forward tomorrow, it would be with a requirement that the tender amount of the outstanding balance be made no later than first thing tomorrow morning to the clerk of court. So just so you know. But I don't know that that's what I want to do, because as I said, when I'm looking at the sort of check the box approach, it does appear that allowing the foreclosure to go forward, the notices were done correctly, even if they were not received. So anyway, let me spend some time with this, and I will get the parties an answer by 4 p.m. today, so that you'll know what you guys are doing. And if you guys have a chance to figure out something else in the interim, y'all do that, and that would be great.
That'll work, Judge. Just one thing I would like to mention, my client actually lives in Oklahoma. And so if we could do it, if you required a tender, let's say by the end of the week, to give him time to get the money here. He doesn't live here. That's the only reason I'm asking. If he was here, if he lived here, it'd be different.
No, I mean, I understand that, but nowadays it is, I mean, it's a matter of calling your bank. I mean, it may be that he's got to get the money together, but nowadays there is documentation that can be provided that the money is here and it can be wire transferred, and that the authorization was given, you know, even if the money's not there, it would be some requirement of demonstration that the money has been transferred, or that the money is eligible there and ready to be paid. Some variation of that, because like I said, nowadays it is relatively easy to say, I have this money, here it is, I've authorized the transfer. You might not have it for 3 days, but at least you know it's coming. So, okay.
Yes,
but I will email the parties. Mr. Ivy, I'm assuming that since we got on Zoom that we do have your email address. And perhaps we also have Ms. Shen, who I think was the original person we were talking with at Aldridge Pike. So we will copy everybody, just so everybody will be clear on what my ruling is. And of course, if y'all come up with something in the interim, let me know.
Thank you, Judge. We'll do.
Okay. Thank you all. Have a good day.
Thank you. All right. Bye-bye. Mr. Ivy.
Yes.
What's your number?
It's 404-994-7655.
Okay. I'll call you right